Are you concerned about what will happen to your family or your assets after you're gone? Do you worry that a loved one, especially a minor child, someone with special needs, or someone financially vulnerable, won't be ready to handle an inheritance after you're gone? Another problem I've seen is, have you ever seen this, though, a family that's been completely torn apart and overwhelmed because a will didn't offer enough protection or structure? Unfortunately, many families, especially in Utah, find out just too late that simply having a will doesn't prevent legal complications. It doesn't prevent delays, and it doesn't have sometimes unintended consequences. There's just no plan sometimes on how to manage your assets or how they're distributed. And when that happens, courts have to step in. It's the responsibility of courts to what we call probate or administer an estate when someone's gone. This can be public, it can be expensive, and it can be very stressful for your heirs. My name is Attorney Jeremy Eveland. I do estate planning and probate cases, and I've spent years helping families plan ahead, not just to distribute assets, but to protect legacies and to give loved ones clarity when they really need it most. My philosophy is pretty simple. Estate planning should be more than documents. It should give you peace of mind, and it should give you protection for the people you care about most. One simple solution is testamentary trusts. Testamentary trusts are not the only solution, and they're not always used, but they can be used and they are a tool. So unlike living trusts that are created during your lifetime, a testamentary trust is built into your will, and it only goes into effect after you've passed away. It allows you to control the how, the when, and to whom your assets are distributed on your terms, not the court's terms. Whether you're trying to protect a minor child, avoid family disputes, support a loved one with special needs, or make sure your spouse is cared for after you're gone, while preserving assets for your children, testamentary trusts offer a flexible and secure solution for you. Here's how it works. First, your will creates the trust. And when you pass away, the will goes through probate. Once the estate is settled, the trust is then funded with specific assets that you've designated. Now, at that point, your trustee, the trustee is a person or an institution that you trust. They are responsible for managing the assets and distributing them according to your wishes. You can set conditions like waiting until a child turns 25 or 30 even, or perhaps when they graduate from college before they get access to funds. You can restrict spending, you can protect against creditors, or even establish charitable gifts. One thing that we usually set up is something called the MESH standard, MESH, which stands for maintenance, support, maintenance, education, support, and health. There are several types of testamentary trusts. Let me explain a few of them to you. One is called a simple trust. A simple trust holds assets until children are mature enough to receive them. Another type of trust is called a spendthrift trust. A spendthrift trust protects beneficiaries from creditors or themselves. A family trust or a pot trust lets a trustee allocate resources based on a child's needs. A Q-tip trust, and we typically use this in second or third marriages. Q-tip stands for Qualified Terminable Interest Protection, QTIP or Q-tip trust. They can provide for a spouse while preserving assets for your children from a previous marriage. And then there are charitable testamentary trusts. Those allow you to give back to a church or a charitable organizations so that it can preserve your family legacy. But whatever your family's needs, there's likely a form of testamentary trust that can be used to match your values to protect your legacy. Now let's talk about the real cost of doing nothing. You see, without a well-drafted testamentary trust, your estate may go through a public, lengthy probate proceeding where court proceedings are part of the public record. Beneficiaries may face delays, they may face legal disputes, or even loss of inherited assets through divorces, lawsuits, or financial mismanagement. Even worse, if your will lacks clear language, the trust might never even be created properly, or It might never even be funded properly, and that could become another legal challenge altogether. By working with an experienced estate planning attorney like myself or someone else like me, you can avoid going through those risks and you can gain for yourself peace of mind. You ensure that your children are protected. You give your spouse security and you pass down your values, not just your valuables. If you need help with a testamentary trust, or if you're ready to build a legacy that protects your family, gives you control, and makes your future easier for your loved ones, give me a call. I'm attorney Jeremy Eveland. You can reach me at 801-613-1472. Again, 801-613-1472. Let's create a plan that works not just for you, but also for your family and generations to come.